It's my pleasure to introduce Dean Lawrence Mitchell of Case Law School, and he will introduce our speaker today. And again, I very much appreciate your putting this together, Michael and Lawrence, and we're ready for you. Thanks.
Thank you, Bruce. Thank all of you for being here. On behalf of our great law school, I'm really proud to welcome you to our annual Cox Center Humanitarian Award Lecture at the City Club of Cleveland. We're very pleased to be co-sponsoring this event with the Greater Cleveland International Lawyers Group. In a city with a legal community as rich as ours, we've pursued a mission of engagement beyond the walls of our law school to share with this community the great work of our faculty and our guests, and to provide opportunities for our students to become acquainted with members of the bar in a variety of areas. Today, of course, our focus is on one of the things that we do best, international law. Our endowed Cox Center, under the leadership of the simply remarkable Michael Scharf, celebrates its 20th anniversary this year and has allowed the law school to become and remain a world leader in the field of international law. You know, you live and die by the rankings, but I'm pleased to report that just last week, U.S. News & World Report ranked our international law program in the top 11. Yes, they rank 11, not 10, but in the top 11 in the nation. Good work, Michael. From our international war crimes work to our work in international financial fraud, from our Utrecht program to our unique in the U.S. China program, from our engagement with issues of international intellectual property to our study of international organizations, and even to the burgeoning internationalization of our law medicine program, there are few areas of the law in which our law school fails to engage with the world around us. The opportunity to present to you speakers like Ambassador Rapp is one more opportunity, and a very special opportunity, to continue our study and engagement with issues of global importance. This lecture would be special if for no other reason than that it is being delivered by Ambassador Stephen Rapp, United States Ambassador for War Crimes. But there's more. Ambassador Rapp has been selected by our international law faculty to receive the Cox Center Humanitarian Award for Advancing Global Justice. This prestigious award, which has been called Cleveland's Nobel, was established in 2004. Past recipients include Hans Corell, UN Undersecretary General for Legal Affairs, Judge Philippe Kirsch, President of the International Criminal Court, my former colleague, Judge Thomas Bergenthal of the International Court of Justice, Luis Mourinho Ocampo, Chief Prosecutor of the International Criminal Court, Robert Petit, Chief Prosecutor of the Cambodia Genocide Tribunal, Navanathan Pillay, UN High Commissioner for Human Rights, and Brenda Hollis, Chief Prosecutor of the Special Court for Sierra Leone. Ambassador Rapp epitomizes the virtues of the humanitarian award and the virtues it was designed to recognize. He has spent the past decade tirelessly working to bring major war criminals to justice, first as a prosecutor at the Rwanda Tribunal, then as Chief Prosecutor of the Special Court for Sierra Leone, and now as U.S. Ambassador at Large for War Crimes Issues. Ambassador Rapp's speech today is titled The Reach and Grasp of International Criminal Justice. How do we lengthen the arm of the law? Well, all one needs to do is look at a newspaper pretty much any day of the week and know that this topic could not be more timely nor more important. There have been many weighty issues of international criminal justice in the news in recent days. Who should prosecute the U.S. officer for the killing spree in Afghanistan? Should the Security Council authorize the International Criminal Court to prosecute President Assad of Syria? Why is Sudan's indicted president, Mohammed al-Bashir, still able to travel freely around the globe? And how is an international tribunal likely to rule on April 26 in the trial of former Liberian President Charles Taylor? I know that Professor Scharf will be present for the verdict. Ambassador Rapp has graciously agreed to take questions from the audience at the end of his lecture. At that time, just raise your hand and a microphone will be brought to you. Since this is being webcast live around the world, we'd appreciate if you would state your name and affiliation and briefly ask your question. That is to say, no paragraphs with question marks at the end. Let me now call one extraordinary man, Michael Scharf, director of the Cox Center, up to the podium to present another extraordinary man, Ambassador Rapp, with the Cox Center Award for Advancing Humanitarian Justice.
Thank you for this. All right, Stephen, if you will join us up here. In the power vested in me as director of the Frederick K. Cox International Law Center, it is my great, great pleasure this year to present our Humanitarian of the Year Award to Ambassador Stephen Rapp.
Thank you. Thank you, Steve. There you go. Thank you. Set this. Do I set it? Where do I?
Before you do, I think she needs a quick
Okay,
picture.
a quick picture.
Hands,
Okay, fantastic.
me lurking in the background.
Okay, thank you. Thank you very much.
Thank you.
Thank you. So, set it here or bring it to?
Well, just hold it for you.
Fantastic. Well, thank you very much, Dean Mitchell and Michael and Case and the Cox Center for International Justice and Law. This is a great honor for me, and it's particularly an honor to be receiving it from this center because of all that you do to advance international criminal justice in the world today, and all you do to train the leaders who will advance it and bring it to greater success in the future. It's brought home to me, I think, every couple of weeks when I open my email and I see a copy of the War Crimes Prosecution Watch, which is put out by the Cox Center together with the Public Interest Legal Law and Policy Group, PILPIG. And just looking at the last issue, I saw that there were 30 countries around the world in which there had been violations past and present in which this newsletter was reporting on prosecutable cases. And as Dean Mitchell said, we only have to look at the newspaper, at the developments in Syria today, where we've had thousands of innocent civilians killed by bombardment. But even worse, and I was just there on the borders last week, we now have men, women, and children being slaughtered, hacked to death with knives in villages around Homs and Dara, and the level of atrocities, if anything, increasing. We see developments in South Kordofan and Blue Nile, frankly, that don't get in the news other than when George Clooney was arrested last week at the Sudan embassy, but horrendous atrocities being committed against people in the Nubian Mountains. And we also see, as we follow the news of international diplomacy, how these issues are playing out at the highest levels. Many of you, I'm sure, saw the news on Saturday of the arrest of Abdullah al-Sanusi, the former head of Libyan security in Mauritania. And now the question has arisen, will he go to the ICC pursuant to the arrest warrant issued by the ICC last June? Will he go to France, which has tried him in absentia, but under the European Covenant would have to try him again, but for the murder of 170 people in that UTA Air flight that exploded over Niger in 1989? Does he go to Libya, where he committed atrocities against his own people over the course of 30 years? Will American law enforcement have an opportunity to talk to him about Pan Am 103 and other acts? So everywhere we see the reach of international justice, but we also have to confront the doubt about whether it has the grasp to accomplish the goals that it set for itself, the goals of having an effective system of justice, of accountability for the worst crimes known to humankind, a system that offers the prospect that victims of these crimes in the past can achieve justice in courts now, and a system that's effective enough to deter those crimes from occurring in the future and preventing other people from being victimized. Certainly in this last 12 months, we've seen examples of where there has been that grasp, where there has been effective results. Most notably with the International Criminal Tribunal for the former Yugoslavia, established now 18 years ago at a time when the world had, I think, relatively low expectations, a feeling that nothing effective had been done in the Balkans. There wasn't the will to send in peacekeepers or civilian protection forces, but instead
the decision was to send in lawyers and judges and establish a tribunal, and little expectation that it would ever reach people at a high level. Now, after having brought people at the level of Slobodan Milosevic to justice in 2001, in the last year we've seen the arrest of the last two major fugitives, General Mladic, who was the leader at Srebrenica, the genocide of 8,000 men and boys in 1995, and Goran Hadžić, alleged to be responsible for the killing of Croatians at the Vukovar hospital in 1995. 161 people were charged by the ICTY. Every one of those 161 were brought to the bar of justice. Even when I was U.S. Attorney in Northern Iowa, I don't think I ever charged 161 persons or group over a period of time and had them all brought to court. At the Rwanda Tribunal, where I worked for 6 years, we've had indeed 83 of the 92 arrestees brought to justice, many at a very high level. And though it doesn't gain a lot of attention during this last year, many of the complex, multiple accused cases of the military and the political leaders responsible for the genocide of 800,000 men, women, and children, only 100 days, their trials have come to a conclusion with historic judgments having been rendered. In Cambodia, I was there on February 3rd, when the judgment on appeal against the leader of the S-21 torture center, where at least 12,000 people were brought to be tortured and to confess and eventually to be executed, with fewer than a dozen surviving. The commandant of that center, having gone through trial and now appeal, his case was finally concluded with a life sentence, and a trial is now underway for the 3 surviving leaders of the Pol Pot regime, allegedly responsible for the murder of almost 2 million men and women and children from 1975 to 1999. Dean Mitchell mentioned that the Charles Taylor case has been announced for judgment on the 26th of April. In the Kenya case, in a situation where the court decided not to issue arrest warrants, 6 political leaders of Kenya, including 2 who were the leading candidates for the president of Kenya in the coming elections, voluntarily came to court under orders to appear, went through confirmation hearings that resulted in 4 of them being charges being confirmed. And the impact of that continues to resonate in Kenya and across the region. And finally, of course, just in the last 5 days, we've had the first judgment by the International Criminal Court in the case of Thomas Lubanga. So there has been an amazing number of developments in the world that I think are positive, that indicates that this project can achieve success. On the other hand, that case that both the Dean and I mentioned in Syria is the one that continues to challenge us, where any prospect of achieving justice at the national level seems impossible before that regime were somehow to change, and the prospect of it being brought to justice at the international level, at the ICC, is realistically blocked by the prospect of a Russian veto in the Security Council. And in the ICC itself, we have to recognize that even after a court has been in active existence for 8 or 9 years, only 5 individuals are in fact under arrest and in detention in the detention facility. Some 9 other living individuals under public arrest warrants remain on the lam. And also, we have to recognize that this period in which I was involved in the Yugoslavia court and the Sierra Leone court, internationalized courts both, is to a large extent drawing to an end. That the ICTY, the ICTR, the SCSL are concluding their work. That the 43 judges that have served in those courts won't be serving in the future. And that the sort of quantity of decisions and action in the area of international law will diminish, and to a large extent be limited to what's happening at the ICC and to such other courts as might be created by agreement at the regional level or hybridized within national systems or in national systems themselves. and with the ICC, of which we're not a member, and I'll be glad to answer questions about the U.S. relationship. We recognize that only 120 countries are members of the ICC, 72 are not. Many of the major conflict zones of the world are outside its territorial jurisdiction, and even in the cases where there is territorial jurisdiction, the crimes often occur in parts of the country in which the state themselves don't have effective control. And so an institution that's based on state cooperation can find itself effective. And of course, when it comes to the Security Council's ability to refer other cases, we have one, obviously the difficulty of getting past a veto in situations such as Syria, and two, the difficulty of achieving cooperation with states that have not accepted the ICC treaty. And at the national level, of course, which the ICC and all of us, and as American policy, we've always recognized, has the primary responsibility to prosecute these cases. There are questions about capacity in many places in the world which have been through these conflicts, who had difficultly challenged justice systems to begin with, and which may have precipitated the conflict, but have devastated judicial institutions after conflict, and simply don't have the capacity to pursue these kinds of cases, and if they do, don't have the will to pursue them except against those that have lost the conflicts. So what can we do and to make this effective? But before I get to that question, I want to pose the other one, which is the system that we have today effective in beginning to deter these crimes and having an effect? I think all of us know that in any system of criminal justice, the prospect that people will be arrested, the prospect that individuals will be convicted, is an uncertain one, and that, but nonetheless, the risk to one's future of such consequences deter many people from committing the crimes in the first place. And so today we have a situation in the world where the risks have risen. Certainly if one is within the territory of an ICC member state, the consequences could be quite clear. There could be an indictment with your name on it. But even if you're not, the prospect that you could find yourself in the dock, I think, is now very real, and is the question in the newspapers within days of the beginnings of the reports of atrocities. The possibility that the international community might find the will to refer the case, the fact that even if it doesn't refer the case, other mechanisms could be established to bring the individual to justice. And we also have the phenomenon of states exercising jurisdiction outside the territory of their courts generally, to bring to justice people that might seek a safe haven in a third country. We've seen successful prosecutions in Belgium, in the Netherlands, in Denmark, in Germany, in Canada, and even in the United States for conduct committed elsewhere. It was mentioned, we both mentioned the Charles Taylor case, but I think many people here are familiar with the fact that Charles Taylor's son, Charles Taylor Jr., who at 19 joined his father in Liberia in 1997 and became head of his anti-terrorism unit and became, according to the evidence, someone who enjoyed torturing people to death, made the mistake of flying through Miami, Florida on a false passport in 2006. And he was then arrested, and because of the fact that he was a U.S. citizen, having been born when his father was a student in Massachusetts, he was charged. I know it takes certain facts in order to make a case, but he was charged, and by indeed the first person charged under the Torture Act of 1994, and for torture of Liberians in Liberia, and after a jury verdict was sentenced to 97 years in prison, a verdict upheld by the 11th Circuit Court of Appeals. And so the danger that in the future you'll face these consequences, I think, has become much more real. Beyond that, and I was recently at a conference with President Song of the ICC, a great, was a professor of law before he was elected to the ICC in 2003, and is now, because of the fact he had a 3-year term and was then elected for 9, he's now in his 10th year as a judge of the ICC, and was last week reelected for another 3-year term as president. But he was pointing out that it was beyond the sort of deterrence that one has to look at these institutions, and it's often hard to prove individual cases of deterrence. But he spoke particularly about the ability of the law and of the practice to establish norms and that filter deep within communities and essentially make certain types of acts unacceptable. And we've seen that with things in the world like slavery and other sorts of crimes that at one time were accepted and then became just totally, still happen, but beyond the pale of human understanding and acceptance. Noting that in terms of doing this, the ICC role and in the international systems role in working with national systems to develop their own legal response to these crimes in ways that fit their particular circumstances is key to that. And I know when those of us, I was involved as a United States attorney for 8 years in the 1990s when we began to see an enormous fall in the rate of crime in many of our major cities, a decline that has continued. And many people have theorized on that, but I have put it down largely to a situation where law enforcement, having been alienated from communities, began to work much more closely with the communities themselves and in their interest, community policing and an approach to law that wasn't completely punitive, but an approach to law that also recognized that it was often the high crime areas, often poorer areas, often minority areas that were suffering the greatest from the crime. That if people were enlisted in their own interest against the scourge, that one would reduce that crime and indeed make the idea that a person would commit those acts unacceptable no matter where they came from. And perhaps that's some of what we've seen in the United States, but I think it's some of which it may be aspirational, but something that I think we can hope for at the international level. But those are the things about what's there today. What I'd like to talk about is what can be done to lengthen that arm of international justice and where the real prospects lie. One thing that's excited me in the last few weeks, and excited me even about the American political system, which many people think is, and we see many aspects of its dysfunction, but we recently presented legislation in Congress to expand the Rewards for Justice program. I mean, this may seem like, after talking about these high-minded things, this is getting rather particular and realistic, but we have a Rewards for Justice system that pays in cases of transnational organized crime and terror. I administer a system for rewards of justice for war crimes, and it applies under our law at the moment only to fugitives from the Yugoslavia, Rwanda, and Sierra Leone courts. And of course, there are not very many of those anymore. But during the last 2.5 years since I've been in this job, because I went back and looked at several cases that had developed over the course of a couple, 3 years before I was there, I've paid out some 14 rewards for information that led to the arrest of certain key fugitives at the Yugoslavia and Rwanda tribunals, and have spent a lot of effort in the case of the Rwanda tribunal publicizing the availability of those rewards in the countries in which we think those last 9 fugitives are hiding. The system as it stands now pays up to $5 million for the greatest risk and the most valuable criminal. We make an evaluation in each case. The largest reward I've paid to date is some $2 million. It doesn't apply, however, in ICC cases or in the case of other courts. We presented legislation that would essentially eliminate that restriction. It says basically that we could pay for any individual charged with genocide, war crimes, or crimes against humanity at any international or hybrid or mixed court, provided the Secretary of State made a determination that this was appropriate. And this specifically would allow a reward to be paid for Joseph Kony of the Lord's Resistance Army and his the two commanders that are still alive. He killed the other two that were on the ICC arrest warrant. And as well, other cases, even in Omar al-Bashir, for that matter. And the program has been recently expanded to pay rewards up to $25 million. And interestingly, and in part because of, I think, the passion, and this was even before the video that went viral in the last 10 days, the passion in Congress on a bipartisan basis for bringing Joseph Kony to justice is we've picked up enormous bipartisan support. From Burton of Indiana, of Helms-Burton fame, to Berman of California on the other side of the aisle, to Ileana Ros-Lehtinen, the Cuban-American congresswoman who chairs the House of Foreign Affairs Committee. They're now sponsors of this legislation, and I think we're looking at the prospect that before the end of the year, this will become law, and we will be able to put out the posters for Joseph Kony and the CAR and South Sudan and the DRC and get the information that we can use within the operation, which everyone also knows that has been deployed, of advisors that are working with law enforcement and military forces in those countries, and bring Joseph Kony to justice. There are, of course, other things that all of these cases involve. In the Charles Taylor case, we didn't have, for the Special Court for Sierra Leone, Chapter 7 powers. We didn't have the right to call up a state like the ICTY can and say it's mandatory on you as a matter of international law. You have to comply. You have to arrest Mr. Taylor. But we did have political support around the world. And we were able to begin a campaign that led to unanimous resolutions in the European Parliament and to a 424 to 1 vote in the U.S. House demanding that Nigeria bring Charles Taylor to Liberia where he could be transferred to justice. And through those kind of efforts and through the isolation of those individuals that had committed these crimes and by making sort of even contact with them inappropriate except for the most essential reasons, we were able to bring individuals to justice, just basically through the demands of all the world. Of course, there will be situations, as I've noted earlier, where we don't have an international court, and we don't have the will at the national level to do very much about it. What can we do then? How can we start this process? How can we at least get a head start on the business of accountability? I found in my job now, whereas for a long time it was involved a lot with existing courts, I now travel, last year, 222 days, dealing with situations all over the world where these kinds of crimes have existed and where because they happened before 2002 or they're outside the ICC, there's no prospect for an international case anytime or anytime in the near future. One of the approaches that we've taken is to press for commissions of inquiry at the Human Rights Council, which we got for Cote d'Ivoire and for Syria, that establish at least the facts and begin the process of investigation. In other situations, we've been able to prevail on the countries themselves, even when there wasn't necessarily a majority in the Human Rights Council, to accept international participation in inquiry commissions, which we did in Guinea after the stadium killings, when more than 100 people were murdered in the stadium and women were raped on the stands in September of 2009, or in Kyrgyzstan, where there were 500 people killed, largely Uzbek, in June of 2010, and where almost 500,000 people were displaced, or in Bahrain, a situation much less serious in terms of loss of life, but still challenging and horrendous, with dozens killed, We had we had commissions of inquiry established with international presence that went ahead and found facts that then demanded that the justice systems within those countries proceed on it, and in each case they did. And beyond simply that kind of approach, there are other ideas that are out there. One idea, this is to take it beyond the commission of inquiry stage, to create a situation where you literally collect the evidence according to a criminal law standard, build cases through international cooperation, that essentially send the message to those that are committing these kinds of crimes, that if they don't punish those that are directly responsible, they themselves could be held culpable, that send the message to others not to follow illegal orders, send the general message, leave the field, don't participate in these kinds of crimes, and if you do, the world can be forgiving, but if you don't, we will chase you to the end of your life. You'll be like Non Che at 85 or John Demjanjuk. Until the day you draw your last breath, the world will not forget. The British Foreign Secretary recently, and they've taken the initiative on this, in the case of Syria, they've asked they've said that we must help ensure that the atrocities in Syria are documented according to an international evidentiary standard suitable for local and international courts, and have called for the establishment of a Syria-wide human rights abuse documentation hub to collect and collate the mounting evidence of atrocities in the interest of justice and that of the Syrian people. A system of criminal justice is always a work in progress. We know that in our own country, where it's not always effective, where it hasn't always been fair, and all of us have to work each day to improve it. The challenge is much greater at the international level. This is a young project. As we all know, it began at Nuremberg, though it was interrupted then during the years of the Cold War. But I'm always inspired by the words of our American chief prosecutor, Robert Jackson, who spoke of a criminal justice system who could reach men of great power, those who possessed themselves of that great power and who used it to set in motion evils which left no home in the world untouched. We're beginning again in the 1990s to build on that progress toward a system that will hold the perpetrators of mass atrocities accountable, toward a system that will ensure justice for the victims of these crimes once they're done, and deter them and protect others from these crimes in the future. A lot remains to be done to make this effective. It's a job for all of us to bring forward that day. Thank you very much. Absolutely.
I am a 1L at Case Western.
Great.
My name is Kenan Castelfoder. My question to you is, through the lens of international criminal justice, what remedies exist now or can be improved upon in the future for bringing to justice egregious crimes committed by Security Council members who hold a veto, such as Russia in Chechnya or China in Tibet, or with the Uyghurs, or the United States in Guantanamo?
Well, that's obviously at the core of the sort of issue that I discussed here. And let me first of all make plain that consistent with the principles of the ICC, and it's the obligation of every state to prosecute their own, and when these crimes are committed, to take them on. And as we see now in the newspapers regarding the beginning of the case against Sergeant Bales for the alleged killing of 16 people in Afghanistan, as we saw with the leaders of the Stryker Battalion who were of the group in the Stryker Battalion who were engaged in killing civilians in Afghanistan in the past. The United States does have a system when crimes are committed, war crimes, of holding people to account, and it's one of the more effective in the world. Indeed, Bill Lietzau, who had a career in the Marine JAG Corps and is now the Deputy Assistant Secretary of Defense, was active in the Rome Conference and thereafter, and was actually a major author of Article 8 of the ICC statute and then of the elements of crime that were adopted by the ICC. I think to a large extent a reflection of the fact that it's the Americans that have had the greatest sort of experience and have developed the most complete system in this area. But of course, obviously you point to crimes committed by other countries in which there haven't been many examples of people being brought to justice in those countries. And as I think, as I indicated earlier, there are other routes. There is the Human Rights Council for commissions of inquiry. That's challenging, but it doesn't have a veto. We're moving this week on Sri Lanka, an ally of China, that successfully in 2009 blocked action by the Human Rights Council. I think there's an excellent chance on Thursday that we'll pass a resolution by a majority in the Human Rights Council that calls further action on accountability involving the estimated 40,000 civilians killed during the last days of the conflict with the LTTE. Accountability certainly for surviving leaders of the LTTE, but also independent investigations for government forces that committed crimes, and that's something in which China and Russia, as members of the Human Rights Council, will oppose. But because of the support of countries in Africa and elsewhere, I think that resolution can pass. Now, will that lead to prosecution? Well, it will lead to greater sort of international pressure on Sri Lanka to do the right thing on a national level, and to the possibility that in terms of engagement with Sri Lanka on trade or aid or other kinds of collaboration, that won't be as easy if they don't do the right thing. Obviously, a more formidable task when you deal with superpowers, but even then, it's a matter of doing what you can to document these things, to get the information out there. I mean, people are full of talk of double standards, and I think part of the talk of double standards actually indicates that standards are being established, that there's kind of an expectation. If you say it's being done here, why not here? And that question's being put time and time again. And the dangers of leaders that were involved in those kinds of things in terms of their hope for a future when they might be able to visit Europe or somewhere and vacation, when they might dream of an exile someplace, that might be foreclosed. And so I think that developing this evidence, putting it forward, making sure that it's there, listening and doing it to a high standard, I think is the approach to take. And eventually, even with the greatest power, I think it results, given the global community we have, in action beyond the expectations of the real politicians. Other questions? Yes.
Somebody's got to ask the Henry King questions, so
Great
will. Late last year, there was an article in the Economist on the ICC entitled "Cozy Club or Sword of Righteousness." When I first read the article, I thought, gosh, they're being a bit critical. But as I read it again, I realized that the article did a number of probably correct things. It pointed out the extent of the challenge, which is enormous. It also pointed out some of the shortcomings in the development of the ICC, which, when you think about it, are entirely predictable and understandable. It also pointed out a lot of the successes that have been had. But overall, I was sort of reminded that this is perhaps a little analogous to the Wild West and the search for justice and the rule of law in the Wild West in the 19th century, and the fact that if you don't press forward and keep pressing forward, you won't succeed. But there, the rule of law prevailed and the justice system prevailed eventually. It took decades, but it eventually succeeded. Do you think that's the lesson of the International Criminal Court and where it's going at this point in time in a similar fashion? Keep pressing, keep moving forward, keep improving, and at the end of the day, we're going to be a much better world than we are now. And secondly, as a corollary to this question, which is sort of the inevitable thing to add in, if the U.S., first of all, do you think there's ever a chance that the U.S. will join the ICC at some point in the reasonably near future? And secondly, if it did, what would be the impact?
Okay. Well, thank you very much for the question. I like the analogy of the Wild West. I mean, one sheriff, investigating, and honest judges and juries, et cetera, that weren't intimidated, make a difference, and it's catching in a way that as one place becomes stable and people can live freely and build and not have the risk that it's going to be taken away from them or destroyed. Other people demand the same thing, and so I do think that there is something to that analogy, albeit that was a question of the exercise of power within a sovereign country that could, in the end, make decisions, could tax itself, could appoint good sheriffs, marshals, et cetera. And in a world of states, you have many places where that's a much more challenging task. And trying to have an international court provide for justice in The Hague when it's very hard for it to be achieved even at the lower level, and when you don't have adequate police and when you don't have adequate courts and other things within the countries themselves, doing it just at that level and not also at the other, I think is one of the difficulties with the ICC, and it's one of the reasons why I'm. Even though the ICC itself says they're not into positive complementarity, which is the business of trying to help countries develop their own systems, because they're not an aid agency, and indeed they don't have a budget for it. One of the areas that I really want to work with the ICC on is strengthening national justice systems, not just in the situation where the country itself is proceeding with a whole case, but also like in the DRC, when there are cases in the ICC, but they're only going to be of 4 or 5 people at a very high level. And there's scores of others that are involved in mass killings and mass rapes, et cetera, that need to be prosecuted at the national level. And so if we're going to make the system effective, it can't just be in The Hague. It has to be at the national level. And one of the reasons why I want to see a more effective ICC is that if it is a 900-pound gorilla that's standing off stage and saying, if you don't do the right thing, if you don't prosecute the people in your country that are doing that are committing these crimes, we'll step in. And would you rather have justice in your own courts or justice 4,000 or 5,000 miles away? You'll have the negative complementarity in a sense. You'll have countries that in order not to have the case go to the ICC will go ahead and do it themselves. So I think there's that part of it that's still missing in the international system. And even to the extent that a lot of us have donor programs involving in rule of law, a lot of these programs aren't really focused, I think, directly enough on strengthening the ability of countries to take on atrocity crime. I'd like to talk, I'm glad to have a question at some point about, whether the ICC is too comfortable or any of these courts are too expensive or trials are too long. I'll save that for another inquiry, but I got the impression that was part of what they talked about in that Economist story. But to go then to your next question about the United States. I get this all over the world, and of course my answer is always the United States is very slow to enact international treaties and conventions, certainly in the area of public law. My friend Harold Coe has has noted, I think, that there are like 32 votes in the Senate that are automatically against any treaty. And so getting to 67 means you don't have much room to maneuver. And of course, it does take 67. As Harold Coe, who's former dean of Yale Law, now a legal advisor, also notes, to become legal advisor, he had to face a filibuster, which, thanks to Senator Lugar and a couple of the Republicans, he was able to overcome. And I think he ended up with 62 votes in his confirmation. And he said, if I'd been a treaty, I'd have been defeated. So you see the difficulty of doing that. And we know it took 40 years to ratify the Genocide Convention. We know that Wilson sold the world on the League of Nations and couldn't get it through the Senate. We know that, we read in the Supreme Court decision on the juvenile death penalty that there were only 2 countries in the world that hadn't ratified the Convention on the Rights of the Child, Somalia and the United States. You know that the Transitional Federal Assembly of Somalia recently ratified the Convention on the Rights of the Child. So we're alone. On the other hand, I was mentioning that to one of your previous award winners, Navi Pillay, a couple years ago, and she said to me, but you Americans protect the rights of the child a lot better than a lot of countries that have ratified the convention. And that goes to that was very nice of her to say, that goes to the heart of American attitudes. We have our own Constitution, we have our law, we have our systems, we built it up, we know how it works, etc. We can protect these rights our way. We don't need somebody from The Hague or Geneva or someplace else telling us what to do. A lot of us in this world have seen the benefits of multilateral action, of working with other countries and how that can benefit. And with an enormous effort and a political campaign, sometimes you can convince people of that and get a treaty ratified. But it takes a real effort, and it takes, like we had when Reagan finally pushed the Genocide Convention, sort of a confluence of political factors that sort of make it look like the right thing to do. And we're not there on the ICC. I think the question on the ICC, I mean, the more substantive question is, why isn't Obama, why aren't we starting this campaign to do it? And indeed, at this stage, we still want to see how the ICC works, how it chooses its cases. There is this fear that an international prosecutor would want to, show how tough they were by prosecuting an American, even if, we came in to save 20,000 people, but 20 people got killed by mistake. They'd say, well, I will prosecute the leader who killed 20,000. We'll prosecute the American too, just to show even-handedness, So there is that concern. On the other hand, you read the ICC statute, complementarity, do it yourself. We do. You have to have, for the prosecutor to move on his own, it has to be a grave case. The suggestion, if you read Article 8, is that you would have to have a systematic sort of war crime, et cetera, not just a one-off kind of thing. So, we'll see how that whole thing develops over time as cases are picked, as judges decided admissibility standards. It may be that at some point in the future, Americans will feel a whole lot more confident that, given what we do, that there really is zero risk for us when we're doing the right thing to be prosecuted. But it'll take some time. Until that day, the approach that we are taking, which is evolutionary from the second Bush administration, when they allowed the Darfur referral to go forward, which would have, sort of changed the policy from that of let's kill this court to this court can be helpful in the world. We basically taken advantage of the fact that the American Service Members Protection Act includes the famous Dodd Amendment that says that we are not prohibited from assisting the ICC in a case involving an individual charged with war crimes, crimes against humanity, or genocide. Of course, that's everybody that's there at the moment. And so we can assist on a case-by-case basis once we've made a determination within our government, which we have in the case of every case where there are arrest warrants. We've said that we support these cases. And we're working to find ways to help witness protection, information sharing, diplomatic, political support, rewards for justice, et cetera. We're going to find ways to help the court succeed when it's doing the right thing, which it is. And I think this will build up a level of sort of confidence over time that'll make becoming closer to the court possible when and if the stars align. But it will be a very long time, given our American political tradition. Yes?
Mr. Ambassador, just to follow up with that, Bill Cotton, Are there constitutional issues with respect to the United States assisting in the enforcement of, taking the principle that you don't ordinarily assist in the enforcement of criminal laws in other jurisdictions? That's why we have extradition treaties. Are there issues that arise out of assisting courts like that from a constitutional standpoint in enforcing their criminal mandate when we are not a member state, for example? Does that raise any constitutional issues?
Well, obviously we've been supporting and we've got laws that say that we can bring people, we can pay a reward for bringing people to justice in Arusha or The Hague or in Freetown in courts. Now, of course, we've more directly supported those courts. A couple of them are UN courts, of which we're a member. Another is sort of a court agreed to between the UN and the country. But I don't think there's a problem with us supporting justice elsewhere. Obviously, there can be, we're trying to do things with pirates, for instance, that Michael's quite involved in, people being picked up by the Carl Vincent, even Iranians rescued from pirates that we recently delivered to the Seychelles to be prosecuted in their justice system. And we've got a few pirates prosecuted in New York, but it's rather expensive. We'd like to get the Kenyans and the Seychellois and others to do these cases. So we're trying to, wherever we can, we're trying to work with others in the interests of justice because we share common interests. We share common interests in the sea lanes free from pirates. We share a common interest in men, women, and children across this planet not being subject to mass murder, rape, and amputation, slavery, and everything else. And so I don't see that there's a constitutional issue. And indeed, I think this is also a case of the spending power. I mean, if we want to get into law school, it's pretty, when Congress goes to work and spends, and it's willing in this situation to say we will spend for reward, that's an area in which congressional power is, I think, pretty clear and almost unrestricted. So once you've got the people's decision to do it. And so I think we're all right in doing that. And as I say, from the left to the right to the center, at least when it comes to cases like Joseph Kony's, everybody in the United States wants to see the scourge of a man who's has killed thousands, enslaved thousands, displaced at last count 465,000 people from their homes, want to see him brought to justice. I should note this, rewards are popular in America. I mean, we always like reward posters, and this is probably something that fits our culture, but this is a reward for information leading to the arrest and transfer of these individuals. This is not a reward that pays for a dead Kony. It pays for Joseph Kony in the dock before the International Criminal Court in The Hague. Other questions? There was I was going to say, in the interest of not looking like a Pollyanna about international justice, that other question that you had, and I think I'm hopeful that we'll begin to see more efficiencies at the ICC, that these trials can be, and this whole process can be a very expensive one, and it obviously disillusions many that this court now in its 9th year finally has a judgment that it involves one individual on essentially one crime of recruiting child soldiers. I think that a key part of the difficulty with the ICC has been the other, and this may sound a little centered from the point of view of my own experience in the ad hoc tribunals, but the ad hoc tribunals took a while to get going. It took a while to sort of manage how to do cases. But if you go to the Yugoslavia tribunal now and you deal with a complex case like the Mladic case, the prosecutor who originally was charging him based upon acts in 40 municipalities of Bosnia, because he needs to contract the case and make it simple, has taken it down to 11, pared down the indictment, Judge Ori, who will be presiding, is putting everyone on a as has happened in other cases, but in this case, even a more restrained clock, an egg timer basically, that says, prosecutor, you've got 250 hours to put on your case, in other words, your witnesses and their direct examination, and you know, if you get down to 220 hours, you've got a lot left, you're in trouble, you know, and so they have, I think, gotten much better at managing situations, which are frankly always complex. These are not, having been a national prosecutor in a national system, a bank robbery can be over and done with in 5 minutes. You've got events that unfold over the course of years, and in order to understand what a leader is saying and meaning and what people understand him to mean, you've got to understand the political context, you've got to know the language, you've got to know the proverbs, you've got to know the culture, and of course every bit of evidence you put on that has another person standing up and saying, no, it isn't, that's not the case, and you have to deal with mass crimes, you have to deal with individuals who are themselves very powerful and who are trying to restrain witnesses from testifying, you've got loyalties to clan, to religion, to ethnicity, to nation, et cetera, which complicate these situations. It is like Dr. Johnson and the dog that walked on his hind legs. It's not that he does it well, it's that he can do it at all. It's the miracle, you know, et cetera. And so, but the ICTY has shown you can do it. And one of the good things, I think, of the 6 last judges that were just elected, 4 or 5 of them have experience in the previous tribunals. And even though the procedures are different, in large part in order to keep the prosecutor from going overboard, he has to do lots of things, lots of stops to the judges that didn't exist at the other courts. It's a system that I think can gain from the experience of what's happened at the ad hoc tribunals. And I look for it to be able to produce judgments about large cases and high-level individuals much faster in the future because of the experience of what's happened at the other courts.
This initiative of more systematically collecting data and material seems to me could be a huge initiative in terms of significance.
Well, obviously, I mean, each of the to the extent, and this is what I was talking about in the Syrian context, and as what Foreign Secretary Haig spoke of specifically, which is to get it done, to get it organized, to get the stuff to a large extent in the bank at the time that it's happening. Of course, whoever comes in will have to look at it again, and there may be holes in it, but it's always best to get it as contemporaneously as possible. And sometimes there are windows of opportunity that appear early that aren't available late. And so I think the world figuring out ways to get out ahead of it makes sense, particularly when you have these incidents of notorious mass atrocity like we do in Syria today.
Well, unfortunately,
Yeah.
we're out of time.
Oh.
We could go on and on, I'm sure. Everybody's just really excited by your conversational talk. But we're going to have to end this here. There are buses waiting downstairs for the students. Can I ask everybody to once again congratulate and thank Ambassador Rapp?
Thank you very much.